Good morning, everyone. Thanks so much for joining us today. Please add any of the questions that you have for Ms. Heather in the chat box today. Today's recording will also be available on the Focus website towards today or tomorrow on the focus-ga.org. It's a pleasure to introduce Ms. Heather. She was here with us last week and she's back again, giving us her time. Heather, take it away.
Great. Well, thank you so much for having me yet again. Really appreciate it. And I love doing this workshop. I was just telling Jade, it's a little different than what I usually do, to actually walk you through how to complete the guardianship petition that you would need to file with the court in order to be appointed as the guardian for your child. So let's get started. And of course, like any lawyer, I have to start with saying, this is not legal advice. It does not substitute for sitting down with your own attorney. It's meant for educational purposes only. And so for those, as Jade said, I went through a lot of this last week, but I just want to give us a little refresh here. And so guardianship, of course, is, whoops, go back there. Okay. Guardianship is when your child turns 18. Up until age 18, you have been mom, you have been dad. What you say goes, at least with entities you're dealing with, maybe not with your child, but legally, you have the ability to make decisions. But when your child turns 18, they are an adult in the eyes of the law and are able to make their own decisions unless a court makes a finding that they are not capable of making their own decisions. So that's what guardianship is all about. Guardianship is legally proving that your child is not able to make decisions on their own, and therefore you need to be put in the place of making those decisions for him or her. So there are actually two different roles in guardianship. First is a guardian, which is the person who is responsible for making health and safety decisions for your child. Second is a conservator. A conservator is the person who is responsible for making financial decisions for your child. And you'll notice there at the very end, it mentions if they have property. If your child doesn't have any income other than SSI benefits, which we'll talk about in a minute, and doesn't have any assets in his name, then you might not need to have a conservator. And in fact, as we go through the petition today, we're not going to address how to file for conservatorship, and we're only going to do a guardianship petition, because most typically for my families, when a child is 17 turning 18 or maybe a little older, you can do guardianship later. And you're not prohibited if you didn't get it done right at 18. But a lot of times when these young adults are transitioning into adulthood, they don't have anything in their name. And if they don't, then you don't need a conservator. You can just go with the guardian. So that's what we're going to focus on here today, because typically that is the case. So in guardianship, and this is another repeat from last week, there are a lot of players, a lot of people who are involved in making a determination as to whether your child needs a guardian and then to getting that guardian in place. So the ones that are in blue are the ones that we're going to address here today, the ones that are involved in the initial filing of the petition. We've got the proposed guardian and conservator. That's the person or people that we're asking to have appointed. We've got the proposed ward. That is going to be your child, the proposed ward, at the filing of the petition. And then once the guardianship goes through, they become not the proposed ward, but they're actually the ward at that point in time. And we hear that word ward and you tend to think, oh my gosh, a ward of the state. No, not a ward of the state. They're your ward if you are the guardian. The petitioner is the person or people who are going to get this process rolling. The petitioner is the person who sets forth the facts and files the petition with the court. And then we skip down a couple because those folks will not get involved until the petition's actually been filed, which is beyond the scope of what we're talking about here today. So the final party that we're going to worry about here today is, of course, the court. That is who you are filing the petition with. So when you file a guardianship petition, the court is going to review the information in that petition and see if there is sufficient evidence to process the petition. If you just file something with the court that says, hey, I need a guardian, and you don't tell the court why, they're going to say, we're not going to mess with this. We're not bothering, our time, our staff, our resources on this. And they're going to kick that petition back to you. So it's important when you put that petition together that you do include and build sufficient evidence as to your child's disability and the need to have a guardian appointed. So that's what we will be addressing in a bit here. And once the petition is admitted for filing, your child has to be served with the petition. And so it's important for you to realize that your child is going to physically receive, you can't receive it on their behalf. And that is either going to be served by a sheriff or a private process server. If it's going to be upsetting to your child to have a armed and uniformed officer appear at your house to serve this, then you can request to have a private processor appointed. But it's important for you to realize that your child does get a copy of it. And if your child does have the capacity to read and understand and see what's being said about them, then you will want to have that conversation ahead of time to let your child know what's coming. And because when you look at the petition, as you're going to see here, we have to make our case. And the way we make our case is by focusing on all the limitations that your child has, which is probably the exact opposite of everything that you do in everyday life. So, but that will be in black and white on the petition in front of your child. And to the extent they are interested and able to read and understand that, you would want to prepare them for that ahead of time. When you file the petition, the petitioners, the people filing, are the ones responsible for the fees. The fees are not insignificant. The filing fee with the court is probably going to be somewhere between $550 and $700. When we file petitions for clients, we collect a retainer of $700 to go toward the fees, and usually they'll get maybe $100 or so back. So be prepared that it is not an inexpensive thing to file with the court. So at the time that we want to just get this petition started, any interested person can apply to the probate court for guardianship. So typically those interested people are going to be parents or a parent and a sibling. You need two people to get the ball rolling. So if we have parent one and parent two who want to do that, or a sibling or an aunt, whoever, these are just people who are going to sign on the dotted line, put forth the facts and say, yes, we believe that a guardian is needed here. Georgia does use standard forms for this, and I emailed a sample form out to Jade that has all of the suggestions that I'm going to make today for how to complete it. That the form that I sent to Jade has that. If you want a true blank form when you're ready to tackle this yourself, you can go to gaprobate.gov. All the standard forms for Georgia probate are there. And the form that you'll be looking for is standard form 12, petition for the appointment of a guardian of an adult. You'll see on there are forms for appointing a guardian for a minor and a guardian for adult. And you might think, oh, well, my child's 17, they're a minor, so I'm going to use the minor form. No, because we're seeking to have this guardianship become effective when they're 18. So even though it might pain you to look at it, it will be you're filing for the petition for an adult, not a minor. Hard to see those guys grow up. Okay, so now this is the actual standard petition, like I said, and you can see down there at the very bottom, maybe you can, these are kind of small. That's where it says standard probate court form 12. So that's what you'll be looking for. I'm actually going to close down my slides here, and I hope that you can still see. I'm not sure if you'll be able to still see this particular thing. I think I need to stop sharing here for a second and pull up my next slide. So what I have here that I'm going to be showing you is that petition, but it's going to have our suggestions as to how you would be completing that petition. And of course, I accidentally clicked. Let me find it. Oh, shoot. Now here I am on the spot. Give me a second. Promise I have it. Whoops. Here it is. Okay. Now let me get back to screen sharing. Okay, now I think we got it. So again, this is the standard form, and you will see here that there are instructions on how to fill it out, sort of, not quite as thorough as they might need to be, which is why you are here today. I'm going to go ahead and make this where we can see the full page. Okay. So this is our standard form, and it will start out with, up here at the top, in the probate court of blank county. You're going to want to fill that in with the county where the proposed ward lives. So where your child lives, presumably the county that that you live in, but maybe if there are, two parents, that just make sure that you're using the appropriate county where your child is known to be a resident. Then right here, we've got the full name. So PW is my abbreviation. You probably figured out for proposed ward. So the full name of the proposed ward, you will put your child's full name right there. Here for the estate number, the court will assign an estate number when you file. So you don't need to worry about filling that out. So here's the title of the form, and you will see that here I have crossed out "and conservator." You can just draw a line through that. Not necessary, but I think it's helpful for the court to know that, hey, we're only asking for a guardian here, not a conservator. Hopefully they would figure that out as they read through the petition, but helpful to let them know up front. So as you can see in the yellow highlights, and as I mentioned, it takes 2 or more petitioners to get the petition started. I'm going to make it a little bigger here. So we will have, this is the petition of person number 1, and then we provide that person's relationship to the proposed ward, and we're going to provide the address of that person because the court will be contacting you throughout this process. So of course they need to know where to find you. They want your physical address and your mailing address. So if you receive mail at a different place, that's fine, but you do need to provide a physical address as well. That's what they mean by domicile here. That's your physical address. So that's person number 1. Now we've got person number 2. Important here, don't forget to initial because they will kick it back, some counties, if you don't have the initial here. And an X might not be sufficient for some counties, so make sure you do actually put initials in there. So person number 2, same information, the name, the relationship, mailing address, and physical address. Then you will see here the word "or." As we flip through the petition, you'll see there's a doctor's affidavit, and people will often tend to think, oh, I got to get the doctor to fill out this affidavit. So then they go through the hassle of doing that. If you have 2 petitioners, you don't need the doctor's affidavit. And I recommend going with the 2 petitioners unless you feel like it's going to be a difficult case to prove. If you feel like you're not really going to be able to convince the court that there is a need for a guardian, or you're afraid that, well, gosh, sometimes my child really gets it together and puts on a great show and the limitations aren't apparent. Only in a circumstance like that would I say go to the effort of doing this doctor's affidavit. If you do the doctor's affidavit, then you only need 1 petitioner and the doctor to sign on the form that we'll see here in a few minutes. The reason I say not to worry about going with the doctor's affidavit is because, as you see down here, the examination that the doctor does of your child and then fills out the form has to be done within 15 days of filing the petition. And it can just be difficult to get that report turned around in your possession, get the petition finished, and get everything to the court within those 15 days. So that's the only reason I say not to go that route. And it's just easier if we've got 2 parents, or a parent and a grandparent, sibling, whomever. It's just easier to go that route typically. All right, so we've told the court about the petitioners. Now we're going to tell the court about the person over whom we think a guardianship is needed. So proposed ward, that's going to be your child, the full name, of your child, and then there's a blank here for age. That age would be as of filing. So you know that for guardianship, they have to be 18, but you can actually file at age 17 and a half. So if your child is still 17, put 17 and a half. Don't just put 17, could let them know, yes, I know the rules, and we are 17 and a half. Then you'll provide the date of birth. So again, they can figure that out with what the age is, but still make it easy on them. The social security number, a lot of people are hesitant to put the entire social security number, but it is necessary to do so. So you do have to put your child's entire social security number there. And important to know that guardianship records are sealed. So this does not become a matter of public record. You probably want that just for your child's privacy in general, but also certainly we don't want his social becoming a matter of public record. So that social security number, the full thing does have to go there, but it will remain part of the sealed record and the public does not have access to it. Domicile, again, for your child, permanent address will go there. And then also where they are presently located. Like perhaps your child is, legally a resident with you, but they're actually located perhaps at an all-inclusive college program somewhere. Maybe they're at Auburn, or they're in Athens, or they're at Clemson. So wherever your ward is physically located, that's what you need to let the court know. And with that physical location, that is where your child is going to be served. So if your child is at Auburn or Clemson, your county is not going to send a sheriff out to that place to serve your child. So you would need to make special arrangements. That might be an instance where you do hire the private process server and say, okay, we're going to have her home from school this weekend. Let's arrange to make it happen then. But that's why they're asking for that address of where they're located, because that's where they're going to go to serve your child. And then you describe the type of facility, whether it's the family home, a group home, dorm, treatment center, hospital, wherever it is they're living, and then a telephone number for reaching the proposed ward. So that's what you would provide there. Now we get into some things that probably in your circumstance probably won't seem that applicable, but sometimes we're filing for a guardianship because there's been a crisis and someone's in the hospital and they might not be there 3 days from now. And so that's why the court particularly asks, will the proposed ward be moved within 3 days? So that, again, just so they can locate them and know where to find them. And then, is the proposed ward a citizen of a foreign country? If they are, even if they're dual citizens, you would want to indicate that here. It doesn't change anything as far as this proceeding goes, but there can be a requirement that you have to let the consulate know, or the embassy know, or someone in the other country know, just depending on where that is. So that's why that has to be there. And if either of those is an answer yes, either they are going to be moved or they are a citizen of a foreign country, they want to know which country, of course. And then also, if they're going to be moved, to where do you expect them to be moved? And even the time frame. Now, section 3, this is what I always call the heart of the petition. The court is asking you very directly, hey, do we need a guardianship? Do we need a guardianship because this person is not able to make or communicate significant responsible decisions concerning his or her health or safety? The answer there, of course, needs to be yes, because that's the whole reason you're filing this. Then for B, item 3B, is a conservatorship necessary? Here, under the circumstances that I've told you, we're operating under the circumstances here today, assuming that we do not need a conservatorship. So we will say no. Then I like to fill in there, the proposed ward owns no property and has no income other than SSI benefits, for which his mother has been appointed as rep payee. If you've been through the Social Security process, you know what a rep payee is, but some of you might not have been yet. So when a child turns 18 and they're going to become eligible for SSI benefits, Social Security makes a determination. Is this child able to manage the benefits on their own? Young adult at that point, not child, or does this person need to have someone else appointed? So let's say they make a determination that your child cannot manage the benefits on his or her own, and so they say, okay, we're going to appoint dad as the representative payee. the representative payee has an obligation to report to Social Security on how those funds are spent. And so because of that, the court says, all right, Social Security is already keeping an eye on that income stream. So we're not going to make the parents account to us as well. So that's why you want to make it clear that there is a representative payee appointed for the SSI, and then there are no other assets in the child's name. So then we would say no there. Now, here is what we have. I should probably highlight this in orange, purple, yellow, green, everything. If you answer yes to A or B, provide facts that support the claim of the need for a guardian or conservator. So that's where the court is saying, all right, you say you need a guardian, tell us why. So for the time being, then they give you these whopping 4 lines to do so, which I can pretty much guarantee is not going to be enough. So what you want to do is say, see attached Exhibit A, and then you'll be able to provide a narrative about your child without the constraints of these 4 lines. We're going to spend extra time once we get through the basics of this petition on how to put together paragraph number 3. So I'm going to just skip that for now, but just know when you get to that point of the petition, you're just saying see attached, and then you're going to provide a lot more information than those 4 lines allow. So moving on to number 4, now we've said, okay, court says, you say you need a guardian, looks like there's something to this, we will proceed with it because you did such a good job filling out paragraph 3. Now they're going to say, okay, well, who should be the guardian? Typically, this is going to be one or both of the petitioners who have filed the petition, but it doesn't have to be. So maybe you're nominating someone else, but whoever it is that you want to serve as the guardian, you're going to put that person's name in there. And then for the conservator, here we're not asking for one, so you would just put NA. But if you were asking for a conservator, then you could put the person's name that's going to go in there as well to serve as conservator. The next thing the court wants to know is what is the foreseeable duration of the incapacity? You know, for some people, it might not be a permanent incapacity. I think in this situation for most of you, and I can't think that I've ever filed a guardianship actually where it wasn't permanent. Or it might be unknown. I take that back. I have done some where, you know, if it was a mental health crisis or a drug addiction case where we could say unknown. But in your case, it's going to be permanent. And so they're saying, what rights should we allow the ward to retain? So what you want to put in here is what I have in red there. Those rights typically retained by a ward. So Georgia law sets forth the rights that a ward maintains, even when under guardianship. The right to vote, the right to object to the conservatorship, the right to hire an attorney to help them object. So there are certain rights that a ward retains, the right to refuse treatment. So you would say, I just want those typical rights retained. Now, there might be some more rights that you want retained. If your child is going to go to an all-inclusive college program, there might be some particular rights that the university requires for them to retain. So you might need to put information in there. Maybe you do want your child to retain the right to get married. I would think long and hard and even talk to an attorney about that, because there are big implications of that with regard to benefits and also with regard to inheritance law and property rights. But maybe you do want to retain that right. So that can be included in there as well. So to the extent you want any of those rights retained, you just would fill them in there. But if you don't have anything in particular, then you can just write those rights typically retained by a ward. So number 6, when you file a petition, there's a notice requirement. Not all guardians are doing the right thing. And so for that reason, the court says, all right, petitioners, here's what you say, but we want to give other people who know and love the ward the ability to weigh in on this. So the law requires notice to be given to, and these are the ones I've highlighted here, to the spouse. If your child is married, then the spouse has to receive notice, as do all living children whose addresses are known, if there are any. So in your child's case, there's probably not a spouse or any adult children. An adult is over the age of 18. So since that's probably the case, we're going to move down to kind of the second category of folks who get notified. We need at least 2 adults. And the order for naming them is, first of all, lineal descendants. So that would be grandchildren, because we've already mentioned the children. So again, probably not going to be any grandchildren for your kids. So now we're down to parents and siblings. So if only one parent is serving as the petitioner, then we do need to notify the other one, even if the other one is estranged, even if the other one's not involved. If you know where they are, you have to list the address here. You can put an asterisk next to it, has not been involved, has not paid child support, has not seen the child in 14 years, whatever the case may be. But if you know where they are and they're a parent, they have a right to be notified of this. So that would be one person. If we don't have a parent, then we go to siblings. The siblings have to be over the age of 18, adult siblings. So if we don't have any adult siblings, we've run through this whole list of folks. Now we're down to just friends. And it says friends, but it can be family members. It can be grandparents, aunts, uncle, cousin, whoever it might be, as long as they're over the age of 18. But you have to come up with 2 people to notify. So the court will include those people on all notices that are sent out regarding the proceeding that is going forth. And that is because, like I said, not all guardians are doing the right thing. And this gives someone on behalf of the ward to step forward and object and say, you know what, they might need a guardian, but it shouldn't be this person, or they don't need a guardian. So that's what this section is all about. And so you're providing that person's name, age, address, and their relationship to the proposed ward. So number 7, this is where the court is looking to see, all right, have there been any prior arrangements made that deal with incapacity for this person? Now, typically, if you've got a 17-year-old turning age 18, they're not going to have powers of attorney. They're not going to have executed a healthcare directive. But if we had somebody who was 80 that we were needing to get guardianship over, maybe they had. So it's just kind of important to keep in mind the context of this form. It gets used for a lot of different folks, and that's why they're asking these kinds of questions. So for 7, they want to know if a healthcare advance directive has ever been executed by this person. Now, maybe you tried that. Maybe you tried powers of attorney and you tried a healthcare directive for your child, but it turned out that it wasn't enough protection, or you weren't able to accomplish the things that you needed to accomplish with it. So now you're having to escalate and go to guardianship. If that's the case, your child has signed these before. And so you do need to disclose it to the court. And also, as you will see here highlighted, attach those as an exhibit, because what the court is looking for, typically within those documents, a preference is stated. If I ever need a guardian, I want it to be X. And so that's what the court is looking for in this, in the document when they ask you to attach it as an exhibit. So has anyone ever been, has been nominated in writing to serve as guardian? That would be part of that advance directive that they're looking for here. Then has there ever been an order relating to CPR issued by the ward or signed by the ward? So that's there. Has a trust been created for or by the proposed ward? So this might be one, hopefully, where you're saying yes. If you have created a special needs trust for your child as part of your estate plan, or potentially maybe your child has a special needs trust already, or some sort of trust by virtue of a birth injury settlement or a car accident settlement, something like that, then if your child has a trust of any type, whether special needs or not, then you're going to say yes over here. So you would just X that box. Then the court says, all right, if you say yes, tell us about it. So if you have just created a trust that's part of your estate plan, that's unfunded, that's just kind of sitting there hanging out, or maybe it's got a little bit of money in it, then you can put something along these lines. The parents of the proposed ward have established an inter vivos third-party special needs trust for the proposed ward, or the parents have established a special needs trust for the ward. And then the court is going to want a copy of it as well. And so that is an important thing to disclose. We used to be able to say, yes, we created it, but not attach a copy. We would kind of give the particulars like the court asks for, but the courts have gotten to the point now where they actually want to see the document. And the only reason we were trying not to provide the document is because a lot of times the filing fees are per page for that. So if you've got a 30-page trust, it can add to your filing fee. But you're probably going to have to disclose that trust. So I'll just go ahead and do it as part of the initial petition. Has any other document been created that gives someone authority to act on behalf of the ward? So checking no there also probably. Does anyone else, as you can see, the court's trying to be very thorough and ask the question coming from every direction so that you have to disclose whatever. So here, just more questions about, has anyone been appointed by the ward to act on his behalf? Then this next one, does anyone have a financial conflict with the ward? If you have a joint account with your child that has significant amounts of money in it, I'm not talking about the checking account that's like a custodial account that your name is on. I'm not talking about the SSI rep payee account. If there is a significant amount of funds in that account that you share with your child, then you might need to say yes here. And that doesn't mean that you're not going to be able to be the guardian or conservator of your child. It just means the court wants to know about it. Because if you're the guardian who's supposed to act on behalf of your child, or the conservator who's supposed to act on behalf of that child or ward, and that money could go to your child and it could go to you, like, who am I going to give it to? That's just where the court just wants to know about it and keep an eye on what's going. So it doesn't mean that you can't be the guardian or conservator. Then we get into this section here, section 9, about emergency guardianships and emergency conservatorships. Sometimes we have to file an emergency guardianship when something bad has happened and we don't already have a guardianship in place and decisions need to be made. So you file that emergency guardianship, and if it gets approved, it's only good for 60 days. And so then you would file your regular petition after that. So if that has ever been done, the court needs to know about it. So that's what the court is asking. Has there ever been an emergency guardianship or conservatorship filed? That's A. Was it created? In other words, was the petition granted? That's section B. If so, they want to know who the emergency guardians and the emergency conservators were to make sure that they're aware of this proceeding, because obviously they've been very involved leading up to that. And has a permanent guardianship petition been filed? The answer there should be no, because you wouldn't have more than one pending at the same time, but it probably happens. There's a reason the court has it on here if people aren't entirely sure what they're doing and what the process is. So that's C. And then was a permanent petition granted? Was that created for the ward? So again, you just say yes or no. And if it has been, then you're going to say who those people are. Then they also want to know, has one ever been denied? The court, Georgia law actually provides that if a petition has been denied within the past 2 years and there hasn't been a change in circumstance, you can't just file again. So you can't get denied and say, oh, I think I didn't put enough stuff in that petition, let's try it again. So that's why another reason it's important to make sure you kind of get it right the first time, so you're not stuck with that 2-year wait. Section 10 here has to do with the conservatorship. So if you were filing for conservatorship, then the stuff that the court is asking here is very relevant and very important. Do they own any property? What assets do they have? What are their monthly expenses? What income do they have? In this instance, we're only asking for guardianship. So what I put on these petitions up here, you'll see in the red, NA, filing for guardianship only. And then you can skip all this financial stuff, with the exception of, I recommend, down here where it talks about SSI, or maybe your child's on SSDI, so Social Security, either one of these. I do disclose that, even though we're only asking for guardianship and not conservatorship. You know, arguably we could say we're not asking about financial things here. It doesn't matter. But I don't want the court to look at this and think, well, gosh, why isn't this child getting Social Security? Shouldn't they be getting benefits? So I want them to know that, yeah, we're aware. We've addressed that. We've got the benefits. Also, if the child is applying, I'll put an asterisk there and say applying for that. And then the starred items are very important. And I just fill it in down here that it is paid or will be paid if you're in the application process to whomever as the representative payee. Again, that's what keeps you out of the conservatorship. So we want to let the court know, yeah, we're aware of these benefits, and yeah, we're working on it, or yes, we have them, but we don't need a conservatorship for them. That's what that's all about. So again, here's what you'll see. This is all the stuff that you won't have to worry about if you're doing just guardianship or conservatorship. And again, I continue to just put NA on the various pages as we go through to let the court know. Not interested. Paragraph 11. A guardian ad litem is an attorney who gets appointed for your child in this process if you are something outside of the box. And probably the most common thing that I see here in this section would be if your child does already have some money in their name and we need to get it out of their name and into a special needs trust so they can apply for benefits, then that's considered a special power. And so you would disclose that if you were looking to do that. Now, again, that's a conservatorship thing. So we're not asking for conservator, so probably not going to be applicable. If you are moving, once you are guardian, you have the ability to decide where the ward is going to live. But if you decide you want the ward to live permanently in another state, say you're moving to South Carolina, you're filing this now, but you know that in 6 months you're moving to South Carolina. That is a power that requires the appointment of a guardian ad litem. So you could put that here and say, yes, we need to get this guardianship in place, but we are, getting transferred to South Carolina, or we're retiring to South Carolina in 6 months. So can we please have permission to move the ward? So you're probably not going to have anything like that. But if you were asking for anything outside of the box, that's where that request goes there at number 11. Now, number 12, again, this, it could apply because people move around, but this portion of the petition was added several years ago, and it has to do with granny snatching. And if you're not familiar with that term, this is, one kid, mom lives in Alabama and one kid's in Alabama, and the kid in Georgia is dueling with that parent, with that child, and is like, no, I want mom to come live with me. And so would go over to Alabama, pick mom up for a vacation, bring mom here and file for guardianship in Georgia. So to put an end to that, which apparently was happening pretty frequently if they updated the law and the forms for it. If the ward has not been physically present in Georgia for at least 6 months, you need to disclose where the ward has been. Now, maybe you just moved here. And so, yes, you would need to disclose that, and who was the ward living with during that time. And did they live alone? I'm about to sneeze. Excuse me. Did the ward live alone? If they were living with somebody, you need to disclose that, and the contact information, because the court's going to reach out to those people and say, hey, what's going on here? So again, it's not really designed for this situation, but if you did just move here within the past 6 months before filing, then it would be relevant to you. Okay, section 13, you just want to copy this verbatim. And so just say to this, it's saying, please give a statement that says the court has jurisdiction over this case. And what you can say is the proposed ward is domiciled in Cobb, Fulton, Gwinnett, DeKalb, whoever, there. And I know that says adordingly, and I fought with the PDF to try and fix it, and I couldn't. So I know it's supposed to say accordingly. So it's domiciled in Cobb County, and accordingly, jurisdiction lives with this court pursuant to, and there's the code section. The proposed ward has not been removed to this county solely for the purpose of filing this petition. So this prevents you from, venue shopping and picking which county you want to file in. So then 14 is just any additional data. Typically, this section stays blank, but if there were anything going on that you wanted the court to know about, you can put that there. So 15 is kind of the conclusory statement. It is in the best interest. That's always the standard the court is applying. Anything that has to do with your child, with the ward, is always, is this in the best interest? So we're saying it is in the best interest of the proposed ward for a guardian to be appointed and for it to be the person that we have nominated. So then you would go through, both petitioners need to sign and provide their full contact information. There's a spot down here for signature of attorney. You can just put not applicable since you're doing this on your own. Then verification. This is where you're signing under oath and swearing that everything you put in the petition is true. So both petitioners need to sign that, and it needs to be notarized. A couple things to look out for on the notary. Even if you're using the same notary, the notary needs to stamp twice, once for each signature. So make sure you get 2 stamps there. Also, if we've got one petitioner who lives here and one petitioner who lives in North Carolina, you don't have to sign on the same page. You can just bring both those pages together and file them both. That's fine. The other thing for the notary is to make sure that they enter their commission expiration date so that the court knows that that's still valid. So those are the biggest 2 missteps that we see on the notarization. Then this is where your proposed guardian signs and agrees to say, yes, if I'm appointed, I will serve. So again, it seems kind of obvious. Of course, you wouldn't be doing this if you weren't willing to serve, but it is a formality that has to go through. So you would just fill all this out, your child's name, your name, and you can just put NA if there's not going to be a conservator appointed. If you're asking to have co-guardians appointed, you know, maybe both parents to serve as guardian, then you would need a consent to serve for both of the parties who are going to serve. So that just gets signed and again, filled in with all the appropriate contact information. This is that affidavit I was telling you about. I just wanted to put it in here in case anyone did need or want to use it. But that's what you would give to the doctor to fill out. But if you're using the two petitioners, you can just leave it out. Don't even need to file it with the court. Then back when we were discussing about who gets notice of this petition, those people don't have to sign off on the petition ahead of time, but they can, and it can speed up the processing a little bit. It takes about 8 to 12 weeks for a guardianship petition to work itself through this whole process, to get through the filing and the service and the court-appointed evaluator and the court-appointed attorney and the hearing and all that. So it takes about 12 weeks. So, having this signed off on ahead of time can speed things up a little bit, maybe get you more to the 10 weeks than the 12 weeks. But so you would just fill it out like you did the others, the county where it's being filed, the name of your child, then the people who are in paragraph 6 of the petition. So maybe that was the adult sibling, the grandparent, the whoever was being notified, they can each sign and get their signature notarized and return that to you. And then you file it along with the petition. And that way you're delivering the court a nice, neat little package where they say, oh, that's already done. Check that off the to-do list and move on to the next step. And they don't have to sign. If they don't, then the court will serve them via certified mail. Okay, and again, same thing for the notary. Make sure they stamp in both places and put the expiration date of their commission. So that is the petition, but of course we need to go back and look at, let me stop sharing my screen here and pull up the other. Let's see. I call this the sample language for the petition. So this is that paragraph 3. Where I have said, okay, you've really got to convince the court that your child is in need of a guardian. So you will have this. I sent this to Jade as well, along with the sample petition. And this just gives you an idea. I put a bunch of different scenarios in here that, it's not enough to say my son has Down syndrome. My daughter has autism. My son has cerebral palsy. You've got to support it with the facts. Okay, yes, the diagnosis is definitely part of the facts, but how does that limit your child? How does your child exhibit? I always ask clients, what would I notice in speaking to your child? And so let's just take a look at some of these samples. And of course, all these names have been changed. So here we've got Jeff. So Jeff suffers from mild to moderate developmental delay and CP. At the age of 22, he graduated with a special education diploma. He's in a vocational rehab program. He's conversant, but has trouble staying on topic. Though he's able to communicate regarding his medical care, he's not really able to weigh and appreciate the consequences of certain choices that are made. He has anger issues. A big thing that works well here, I find, for courts is if you can give an equivalent or something. An IQ test is helpful as well if you've got an IQ. But if you have a grade equivalency, my child reads at a 3rd grade level, my child does math at a kindergarten level. Anything like that can be very persuasive to the court. Just kind of puts it in terms that the court can understand and grasp. A lot of the terminology that as a parent might not mean anything to the probate court who doesn't live and breathe your child's medical history. So, any limitations that they have as far as activities of daily living, what are they able to do on their own, functional level in school, safety awareness. Do they recognize stranger danger? Could they be easily taken advantage of by other people? Is it safe to leave them alone? And if not, why? What concerns do you have? And so all those sorts of things, you're really just painting the picture of your child. So that was Jeff. And now if we look at Mike, so Mike has, again, moderate intellectual disability, autism, and a seizure disorder. How does he communicate? He's able to read single words or short, simple sentences. He's able to make, for instance, a 2-word request like want more, want movie. He's able to communicate, but is he going to be able to express this, first of all, to someone who doesn't know him, the way he communicates with you? Does he have anxiety that, prevents him from being able to communicate with others? So does he have behaviors that make it apparent that he's not able to, handle himself in certain situations? So there's some circumstances that might surround that. Now, this one you'll notice is pretty short. And that is because if we have a child who is nonverbal and cannot communicate through an assistive device and has limited cognitive functioning as well, that's going to be a pretty short descriptor. You don't need to go into everything that has to be done for them. When you have a description here, like we have for this proposed ward, Jordan, it becomes apparent that there's going to be a need for a guardian if there's a lack of ability to communicate at all on their own behalf. So if your child falls into that category, maybe you could fit it in those 4 lines that are on the petition. So here we have Mary, who has been diagnosed, was born with Down syndrome. And, so here you'll see we've included an IQ evaluation. And then we've also got here saying that she's not capable of understanding and evaluating decisions. And she regularly sees 10 physicians and is on numerous medications that need to be monitored. That's another big one. How is medication administered? Do you have to watch and monitor and make sure that it's been taken? I find that really persuasive for courts as well. So then a few more. We've got Janie, who has cognitive disability, bipolar disorder, and OCD. Again, we went with an IQ score. Then we've got things like here requires 24 supervision. That's a big thing. And then also here, do they report when they're in pain? Are they able? A lot of kids have really high pain tolerances, and you kind of, they're acting a little funny, but they're not able to express what's wrong. And you have to do a lot of detective work. If that's the case, I always include something like that in the petition. So then the last one I had here, so this is a child who's been diagnosed with Prader-Willi syndrome and, must be monitored constantly, needs 24 supervision, and no ability to meet daily living needs on their own. If you can't be around food like that, then it can be hard, obviously, to care for yourself without assistance. So in a lot of this, so this is going to be paragraph 3 of the petition, and where it says, if you've answered yes, tell us why. So that's really what you want to do. You want to beef this up, because when the petition crosses the desk of the clerk at the court, they're going to look at that petition and say, okay, if this just says Jeff has autism, so some people have autism, need a guardianship, some people don't. So you've really got to show how it manifests and build your case. That's probably the most important takeaway from today. The rest of this you probably could have figured out on your own eventually with the help of a good legal dictionary. But making your case is really going to be the crux of the matter. So I'm going to stop there for, let me find the chat. I see there are 4 things in the chat. So let's see, let me get up to the top. Okay, my child is a dual citizen. Do I still check the box for a foreign citizen? Yes. You're going to put both, and I would still put that, dual citizenship USA/Canada, but absolutely you want to disclose that. Okay, sibling is on a naval ship on deployment. Is this a problem? If it's an adult sibling, they do need to get notified, but you could certainly say that they are on that ship with deployment. I would probably do that and say attached. Hopefully you can get a text or an email or something. A text is an email that says, I'm aware of this petition and I have no objection and think my mom is wonderful and should absolutely serve as my brother's guardian, something like that. I recognize you may not be able to get a notary out there, but just letting the court know those extenuating circumstances, I would imagine they'll work with you on that. Never had that one. Does each petitioner fill out a separate form or both on the same petition? Both on the same petition. So that one petition is going to serve, you just want both parties to participate and sign it. Not eligible for SSI until he is 18. So filling this out won't have SSI. Do I put we are in the process of SSI? Yes. So I would do exactly that on there where it says the Social Security income, just put applying will be paid to representative payee. That's the main thing that you want to get in there. Father lives in another country. What is the best way to prove the court I can notify him about the guardianship? So even if he's in another country, he will need to sign off on that petition. So the only difficulty that typically comes with that is getting a notary. Depending on where he is, notaries might or might not be accessible. There might not be a similar concept, but usually going to the embassy or the consulate and contacting them for information on how to get a notary. So the US embassy in whatever country it is, or the consulate. So kind of a pain in the neck, but does need to be done because you got to get that notarized signature. I want to put my older son as a petitioner. What happens if the father does not agree? So it is fine for your older son to be the petitioner along with you. It doesn't have to be the two parents as the petitioner, but the father is going to get notified. If he does not agree, then he needs to let the court know that. He needs to file an objection and say why he doesn't agree. And if he thinks he's the one who should be appointed, you know, these can get complicated. If you think that's going to be the case, you probably should have an attorney involved. But a lot of times, you know, if you think they're not going to agree and not be happy about it, well, if they don't do anything about it, then it just goes through, as long as they have been notified. But if you think there's going to be an objection, then you probably would want to get an attorney involved or file it and see if there's an objection filed, and then you could get an attorney at that point. What is the cost and process if you file for conservatorship later? So this is an interesting question. I was trying to keep it simple for today, but since this has been raised, I will let you know it is possible to file for what some courts call a suspended conservatorship, where you would say, yes, we want a finding of a conservatorship, but we don't want a conservator appointed just yet. That saves you from having to go back later and do it. So if you're in a position, we most commonly do this where we think the child will be employed at one point, you can say, okay, I do want a conservator. And so the court would go through and make the finding of the conservator, which means you would have to fill out all that information about the conservatorship. But then you go on to say, well, yes, we need a conservator, but there's not any money right now, Judge. So will you please just suspend it? Go ahead and make the finding, but don't require us to post bond or file annual returns because there's nothing in the conservatorship at this point. So you can file and ask for that. Then later on, 3 years from now, when your child does have a job and is making money, you file a motion to the probate court to activate the conservatorship. And a motion would probably be a couple $100 to get that done, as opposed to if you hadn't done it on the front end and you were starting afresh with a conservatorship, it's going to be that same filing fee, $700, and the same petition, but it's just as opposed to eliminating all the guardianship, the conservatorship stuff, you leave all the guardianship stuff blank and say you're just asking for a conservator. So it is possible if you think a conservatorship will be needed down the road to kind of go midway and get a suspended conservatorship that you just, you know, quote unquote, activate later. How does the existence of a 529 account affect this process? There have been no withdrawals from the account. So a 529 account does not affect this process at all. And it also does not affect SSI eligibility. And that is because a parent is the one who sets up a 529 account. And a parent can revoke that account, can take all that money back at any moment. They'd have to pay taxes and penalties for doing that, but they could. And so for that reason, the court says, okay, well, sure, it's a 529 for this child, but they don't have any control over it. So it does not have to get disclosed or mentioned or anything on the guardianship petition because it's not your child's, it's yours. or whoever set it up. I know about the NA for assets. What about expenses? Same thing. If you're not asking for a conservatorship, you can put NA on there for the expenses as well. Is it best to have a single guardian or should both parents be appointed? My lawyerly answer on this, of course, is it depends. I would say the majority of petitions that I file, the parents decide they want to be co-guardians. The important thing to recognize on that, though, is that guardianship is not an either-or situation. It is two halves of a whole. And so if you're in the emergency room with your child and you have your letters of guardianship that say you and your spouse are the co-guardians, the doctor, emergency room, whoever is well within their right to say, okay, that's great, I'm glad you're here, but where's the other guardian? We need to hear from them too before we do anything. Now, in this day and age of FaceTime and whatever else, you could probably get them on the phone in a way that would satisfy the court. But if someone's going to be inaccessible, or if someone is the one who always does the doctors and always does this, you might choose to just have that one parent be the one who's going to be in those shoes. But so there's no right answer on that. It's just important to realize it can be more of a hassle to have the two names. It can feel like too many cooks in the kitchen at sometimes, but I've just, in my experience, more often than not, parents still choose to go that route and haven't come back to me saying, oh my gosh, this is awful. Why did we do this? We want to have one of us resign. Okay, is the child able to work later? Do we have to do something in this form to notify the court later? I think I answered that. So yes, perfectly fine for the child to work later. It's just that if they are earning income and receiving that income, that needs to be disclosed to the court and a conservator appointed to manage that income for them. We have neuropsych exams that we use for SSI. Should we include those in the petition? Thank you for asking that question. I forgot to touch on that. With the exhibits, when you're saying, okay, yeah, I'm putting all this in my paragraph 3, but would it help to have, hear this coming from a neuropsych evaluation? You can include that if you want to. It is really not necessary. And it's also not admissible at the hearing unless the person who prepared it is there to testify about it. So really, the standard here is a preponderance of the your case, which is kind of a low bar. And so the court is going to be perfectly happy hearing from you. If it's a borderline case, then you might include the neuropsych evaluation. That at least gets it in front of the evaluator before the evaluator meets with your child. And then they might have some clue as to what they should be looking for. But it is not necessary. And I would say if it's not a borderline case, I wouldn't even worry about including it. Just give your narrative. You know your child best. Where in the application do we request a later conservatorship? I would do that under the additional data portion. That last thing I said that usually it's left blank. First of all, going through on the, I don't know if this is going to let me switch back. Maybe it did. Okay. Let me get my chat out of here. So I would say going through in the petition, things that would be different if you were looking for that suspended conservatorship. You are going to say, here at 3, you would say yes, necessary. And then down here, I would say, currently the ward does not have any assets. Accordingly, we're asking for a suspended conservatorship that can be activated at a later time when it's anticipated that our child will have gainful employment, or the proposed ward will have gainful employment. So I think this section would be different. You would mention something about it there. If you're doing the suspended conservatorship, you don't need to do all that expense information anyway. But then the other place that I would put it would be right here, so paragraph 14, where it says where full particulars are lacking. I would put it there. And then the other place where you nominate the people to serve, you would want to put the name of the person in there that you want to be the conservator one day, right here at 4B. Okay. Then someone's asking how to get a copy of this recording or documents. Jade will be able to get you the recording and the documents. I've sent them to her, and I know she's recording. Is this all we need to file? What about pages 18 through 48? Okay, I know there's that big, intimidating, bold print that says you have to file all pages. You don't. So just the pages that I've disclosed here, that's all that you need to file. Oh, here's another programming idea. Do you have a webinar for starting the SSI process? I do not, and I actually would not be the one to initiate that process. We do not handle SSI applications in our office. I know that another big supporter of Focus is Angel Burgess with Burgess and Christensen. She's a great attorney that we referred SSI work to. So maybe Jade, that would be a program there. Maybe there's already been one. But there's, I think that would certainly be helpful on letting people know how to get started on SSI. Okay, then we've got one. I am confused. If I want to be just myself as an appointee, where should I state it? Page 1. Okay, so page 1 is our petitioners. So you've got to have 2 people there. So this is going to be petitioner number 1 up here, and then petitioner number 2 down here. So you've got to have 2 people listed there. But if you're asking only for yourself to be appointed as the guardian, then it's right here, number 4. So this is saying, you know, we've got Bob and Sally who are filing the petition, but we just want Bob to be the guardian. So we just put Bob's name in there. Hopefully that helps with the confusion. All right, I think I went 2 minutes over. Do we put 2 names in there for co-guardian? Yes. If you want to have co-guardians, then at number 4, you would put both names as co-guardian. So, all right. Well, I thank you so much for sitting with me through this. I know it was drinking from a fire hose. I'm glad that Jade recorded this. And I think, you know, the handouts will serve as a great help as well in putting this petition together, but you can certainly get this done on your own.
Heather, thank you so much for sharing all your knowledge with our families today and just giving us your time. We could not be more grateful.
Oh, you are very welcome. I see one thing pop up in here. Can I ask one more question? What are the page numbers to be filed? It is page 1 through 17. 1 through 17 are the page numbers to be filed. So thank you again, Jade. I appreciate it. And I look forward to seeing everybody soon at a Focus event.
Thank you, Heather, and everyone have a wonderful day. We appreciate your time, Heather. Bye-bye.
Absolutely. My pleasure. Bye.